So let's take a look at some of the examples that you may see arise out of the content from Chapter 10. Basically, let's look at some instances of contractual defects. So, first example, incapacity. Let's look at Charlie. Charlie's 15. He enters into a 2-year contract with TELUS for a cell phone. Can he avoid the contract? The default rule is that minors who are under the age of 18 do not have the capacity to contract. That means that the contract that they enter into is voidable. So it is possible that he's going to be able to avoid the contract. The only potential argument is, of course, whether or not the contract for a cell phone is a contract of necessity. You'll recall that minors are not allowed to avoid contracts that are contracts for necessities. And the reason for this is because you want minors to be able to enter into contracts for necessities if they have to, and people are not going to want to if they know that the minor is able to get out of it. So it is a potential argument that TELUS may have that it is a necessity in modern times to have a cell phone. The second question, if he avoids the contract for 2 months, what is he liable for, if anything? Being able to avoid the contract is not an ability to avoid the obligations that have already come due. So he is going to be obligated to fulfill his end of the contract for the first 2 months before he avoids it. What happens when he avoids it is that he's not going to be liable for the remainder of the performance, so the remaining 22 months. Conversely, TELUS is not going to be obligated either. And the final question, can Charlie avoid the contract after a year? And the answer in this case is that probably not. The question the court's going to ask, or is going to be asked of the court, is whether or not Charlie affirmed the contract. Are we far enough into the duration of the 2-year contract that Charlie can be said to have affirmed? And that's the question that the court's going to be asking. Now let's look at Alan. Alan's schizophrenic, refuses his meds. He gets a credit card, racks up 10 grand, and refuses to pay. The first question, can he void the contract? And really, this answers the second question as well. Whether or not Alan can void the contract depends on whether or not there's a court order out there. If there's a court order declaring Alan incapacitated, then every contract that he enters into is void. It's void at the outset, regardless of whether or not the other party knew that he was incapacitated. So if there's a court order, yes, the contract is void. It's not even voidable, it's void. Now, if there is no court order out there declaring him incapacitated, the question then moves on to whether or not the other party to the contract had reasonable knowledge that Alan was incapacitated when he entered into the contract. If it was impossible for the bank or the credit card company in this case to determine that he was incapacitated, then Alan's not going to be able to void the contract. He's not going to be able to get out of the obligations. If, however, it was possible for the credit card company to determine that he was mentally ill at the time, then it is a situation in which Alan can void the contract. The contract is voidable. Let's move on to the next example. This is an example of the statute of frauds. Mike and Ike verbally agree to rent Sheila's condo over Christmas 2021 while having a pint with Sheila at Rat. Is it void or unenforceable? This is one of those contracts in which the statute of frauds requires the agreement to be written. Why? Because performance is going to happen more than a year away. So it is unenforceable. If they wanted to enforce it, if they wanted to make it enforceable and only had a napkin, what would they write? They would have to write the terms of the party, or they would have to write the parties, the terms of the contract itself, and make sure that basically the substantial terms of the contract are written down. Let's look at the next example. Josh orally agrees to purchase Blackacre from Trump, paying $5,000 to secure the transaction. If Josh breaches the contract, can he sue for his $5,000 back? And the answer is no, and it's a nuance of the statute of frauds. The statute of frauds doesn't render a contract void. The contract still exists, it just can't be enforced. In the other example, however, if Trump breaches the contract, can Josh get his $5,000 back? The answer would likely be yes. It's not that Josh is suing for the enforcement of the contract, i.e. suing to force Trump to transfer Blackacre into his name. It's that Josh is trying to get his $5,000 back. And in that case, it's likely that the court's going to, rather than deal with this through a situation of damages is going to be looking at restitution, because there's no reason for that $5,000 to have been transferred. Let's look at the next one. Mistakes regarding subject matter. You contract with agency to have Daphne attend your corporate Christmas party. Party arrives, and Daphne, an exotic dancer, arrives. Whoops, neither of you nor the agency knew of the other Daphne. Was a contract created? This is a situation where the parties have entered into a contract where both of them have agreed to a certain term, Daphne, with neither party realizing that there's another Daphne. This is a situation of mistake. It goes to the consensus ad idem, and the answer is that no, there wasn't a contract created in the circumstance. Then we look at the art gallery example. During an art gallery event, you agree to purchase a painting of the Edmonton skyline for $5,000, mistakenly believing it to be by a famous artist. You find out later that the painting is worthless, except to the parents of the painter. Let's say it's one of my paintings. The first question, was a contract created? In this circumstances, it is likely yes that a contract was created, particularly because you saw the painting and you paid $5,000 for that painting. That is your mistake. It's not actually a mistake that both parties hold at the same time. Are you able to recover? Probably not. However, this would be different if the art gallery had made a misrepresentation. So if the art gallery had made either a negligent or fraudulent misrepresentation that this painting was done by a group of 7 artists, then there would be the potential for damages. Poor Daphne. So going back to the Daphne example, you have a contract with an agency to hire Daphne. However, you discover that Daphne passed away prior to the contract. This is a situation in which there has been a mistake in the existence of subject matter, and therefore there is no contract. Compare this, however, to the second circumstance, which is where you have entered into a contract to hire the jazz performer Daphne, and you find out that a day before the party, so after the contract has been entered into, but before the performance of that contract, Daphne passes away. Was a contract created? Yes. Contract was created. What is happening here is that the contract has been frustrated. Performance of the contract has been frustrated. Could a contract contemplate what would happen in this circumstance? And this is exactly what a force majeure clause could do. A force majeure clause outlines the parties' responsibilities, the parties' obligations, if something happens that is not the fault of either party that prevents them from fulfilling their end of the bargain. Moving on, let's look at duress. Surprise Consulting enters into a contract with Mike Ltd. To supply audiovisual equipment for a national conference. 2 days before the conference, Mike Ltd. States it cannot perform the contract unless Surprise pays more money and rents more sophisticated equipment. What are the factors that a court would look at to determine whether or not there is duress? Well, the court's going to look at whether or not the pressure was made in bad faith, whether or not it was such a circumstance that basically Surprise Consulting basically couldn't reasonably refuse. It was so late in the game that they couldn't get anyone else. The courts are also going to look at determining whether Surprise Consulting immediately started legal proceedings rather than just sitting and waiting on the circumstances. The court's also likely going to be involved if Surprise Consulting agrees to the increased amount, but does it under sort of complaining, under protest. They agree to the additional amount under protest. Now, if duress is found, what's going to happen? Well, what's going to happen is the contract is voidable at Surprise Consulting's option. Here's another example. Joyce agrees to purchase a Porsche from her psychiatrist, Dr. Payne, for $70,000. She changes her mind and wants to avoid the contract. This is a circumstance in which there is an inequality of bargaining power. In this case, the court will reverse the burden of proof, and it's going to be up to Dr. Payne to prove that Joyce did not make the agreement under duress. What circumstances would help the psychiatrist? Well, if Joyce had, first off, if it was a market value, if it was a decent transaction. Another thing that's going to help the psychiatrist is if Joyce entered into the contract with legal advice. What circumstances would help Joyce's case? Well, I'll let you answer that one. So another example. Jen agrees to sell her stockpile of 500 pseudoepinephrine pills to her neighbor Walter. The sale contravenes regulations. Will the court enforce this contract? And the answer is no. It is going to be void for illegality. Compare that, though, with a circumstance if it's 500 apples instead. If the sale still contravenes regulations, is it likely a court's going to enforce this contract? The answer is probably still yes. It's not the type of regulation where there's a public policy issue regarding the level of illegality, and it's likely that the court is still going to enforce the bargain.